Hi, I'm attorney Skip Reynolds with Skipton Law Estate Planning and Elder Law here in Centennial, Colorado. And on today's video, what I want to talk about is the fact that just because you have a trust doesn't necessarily mean that you're going to avoid probate. So we talk to lots of people who come into our office. Maybe they've done their own trust, maybe they worked with an attorney and done their trust, but just because you have the trust doesn't necessarily mean that you're going to avoid probate. Because having something in writing, while that's a good step, I definitely encourage people to do those things, it doesn't mean that your assets are quote unquote in the trust. You must do what we call trust funding. And actually that's one of the biggest things that we see as a mistake done by people, because they don't integrate their assets. So us attorneys, we're great at doing great documents. We can mint gold on paper. But if you don't take your asset and insert it into your plan, it doesn't matter how golden that paperwork is, it may not work to the effect that you wanted, or extra steps may be involved in order to get it into that trust. So here's what I mean. I'll give you a story. So if you have a trust, in order for an asset to get to the trust, it must either be designated as owned by the trust, or if it's an account, it must designate the trust as a beneficiary. This is the trust funding. So we've had experiences where we've talked to folks where they've had a great trust. The trust says exactly what they wanted, but their assets weren't integrated into the trust. And in one particular case, it was a scenario where it was real estate properties, and there were very specific rules inside of the trust of how to deal with those properties once this individual passed away. The issue is of the three properties, only one of them was actually in the trust. So when the person passed away, there was a probate necessary to move the other two per the person's will, which is what's called a pour over will, meaning dump everything to the trust. But we had to do that with two of the three properties to move them to the trust so that the rule book inside of the trust would occur. So the trust was good. It had the rule book that the individual wanted, but the funding of the trust, the integration of the trust was not complete. And so therefore extra steps were involved. Now we still were able to get it over to the trust in this particular example, but it took longer, took more work than maybe the individual had intended. Now that's a story of somebody who it worked out fine. One of the questions we hear is, well, if I have a trust, why do I need a will? Well, if you don't have a will, like in my story just a second ago, now I don't get to control whether it ever gets to the trust or not. So we've run into a situation where that was exactly what happened. The individual had done their own trust, did not do a will, had not created all the beneficiary designations that were necessary or the retitling that was necessary for their assets. They passed away. There were assets that had to go through the will or the lack thereof in this particular circumstance. And because there was no will, because the will wasn't there designating it all to go to the trust, the beneficiaries were different, because now we're following the state statutes, not your plan. So the integration of this trust is key. Again, you can mint gold on paper, but if you don't get your assets either titled in the name of your trust or designated to go there as a beneficiary, the trust can say all kinds of great things and it may or may not work out the way you want it. If you like this video, you can find other videos like it on our YouTube channel. You can hit subscribe there and you'll see any new videos that pop up. Or if you're seeing this on a different form of social media, feel free. We've got other videos like this. In addition to that, we also do bi-monthly workshops where we're talking about powers of attorney, wills, trusts, probate, how to protect your estate from long-term care risks, how to protect your estate after you've died. If you want to sign up for one of those, there's two ways you can. You can go to our website, which is www.skiptonlaw.com, and you can click on the workshop button there, and you can sign up there, or you can call our office at 720-440-2774, and we'll get you signed up that way as well. Thank you again for watching this content. Again, I'm attorney Skipton Reynolds with Skipton Law here in Centennial, Colorado. Thanks so much for your time, and we'll see you again.